thank you all for being here, and particularly thank you to the lawyers for agreeing to do this argument at this location in this venue. We are here today on our case number 1CACV180534, Campbell versus Pfeifer. As you know, you both know quite well that we have 20 minutes for each side, and I hope you have some way in front of you to know the clock. There you go. The number's on the way over there. We are recording the argument, even though we're out here. So we'd be grateful if you would, when you approach the podium, give us your name and the name of your client. We've read the briefs and done the legal research. We've also, of course, reviewed the record. We've also conferenced the case. So with that, Mr. Abney, you may proceed. I'm not sure that's working.
Okay, I think it's on now. Okay. My first job was to turn it on.
Okay.
I think it already was, so somebody else did my job. I wish somebody else would do my argument, but...
It's going great so far.
Yes, thank you, sir. May it please the court, my name is David Abney. I'm here representing Courtney Campbell, who is also here today. The main issue, and really the issue that takes care of everything, if you agree with me, is the mere acceptance rule. There was a demand in the offer that it could only be accepted, and those were the key words, only be accepted with an affidavit of no other applicable insurance. And the offeree did not provide an affidavit. The offeree provided a declaration. Although there is an issue as to whether it was actually received or not, the offeree says, we've sent you the declaration, and of course there's a dispute about receipt. But the key issue is the mere acceptance rule. The common law for hundreds of years has rested on the simple principle that if you demand a specific kind of performance or a specific kind of acceptance, and you don't give that, then there has been no acceptance and there is no contract.
So under your view then, if the offer or the demand required that the affidavit be printed on red paper, and if it were printed on sort of a maroon paper, that would be enough to throw off the acceptance?
I'm colorblind. I think maroon is something like red.
That was why I chose it.
Yeah, well, yes. If it was not exactly red, then that would be no good. You could say you want it on flowered paper with perfume. Whatever you want to say, you were the master of the offer.
So the declaration that the insurer says it sent was a sworn declaration. It didn't say affidavit on the top. It said declaration. How would it have been different substantively if it were indeed an affidavit?
Well, it's not just the name at the top. If you put an affidavit at the top of a document and it's not administered, the signature is not administered before an officer who's authorized to accept oaths or affirmations and not properly done that way, it's not an affidavit. You can put the label affidavit on it. It won't be an affidavit.
So even though it was sworn under penalty of perjury, it says the fact that it was not signed by a notary as having been affirmed and sworn before the notary, that's the distinction that you make.
Has to be affirmed or sworn before a judicial officer who is authorized by law to perform that function, and it wasn't done, so it's not an affidavit. And if it's not an affidavit, there has been no mere acceptance.
Can you imagine any practical situation in which the difference would matter? Because if the veracity of the representation of no applicable insurance were to be tested in court, Rule 80C would provide that a declaration has exactly the same effect as an affidavit. So what's the difference?
Unless I engage in some sort of flight of fancy, I don't see any real difference.
Okay, so then your position really is that the substance doesn't matter. Any arbitrary condition is good enough to throw off an acceptance.
Any arbitrary condition at all. Professor Carl Llewellyn once said that the difference between lawyers and non-lawyers starts in contract class. When you can understand consideration, offer and acceptance, and contract law, your mind has been forever ruined, and you don't think the same as anybody else.
Professor Llewellyn also said in that context that law school sharpens your mind by narrowing it to a point.
Yes, and we are at that point now, and the point is, under the mere acceptance rule, it has to be an exact mirror. If you put in there, it can only be accepted. Now, the Uniform Commercial Code has changed things a bit, and there's been some loosening in general, but if you just said, if you didn't have some specificity like can only be accepted, you can slide away from the mere acceptance rule, but here you can't do it because of the only be accepted language.
And this is a common law contract, right? The UCC does not govern.
It does not govern.
And with respect to, tell me more about why, if a declaration complies with ADC, it wouldn't comply with the offer here.
Well, whenever
And I always think
it's
about
ADC,
Right.
it talks about when these rules require or allow a matter to be supported, evidence established, et cetera, et cetera. And these rules don't apply to a pre-litigation contract offer and acceptance situation. It's not within the rules of civil procedure.
There's a federal statute, though, that comes to the same result that applies even more broadly.
28 U.S.C. 1746.
Yeah. So how do those, let's say ADC, for sake of argument, doesn't apply because it doesn't talk about these rules. But tell me how it's different under 1746.
Well, I don't think anybody briefed 1746. So
I read the briefs the same way.
Although I've used that before in other contexts, and I would have to see the exact language of 1746 to give a truly intelligent answer. Beside the fact that that argument has been waived is not part of this, we're dealing with the common law specifying and requiring and demanding that there be a mere acceptance, and there was not. An affidavit is not a declaration. It may function the same as a declaration for practical means, but it's not the same.
If there's a question of fact about whether the declaration arrived on time, then it doesn't matter, does it, for our purposes, whether it was a declaration or an affidavit. For your argument, it didn't, whatever it was, it didn't arrive by the date it needed to.
Right.
That's what your expert and your witnesses testified to. So let's talk about whether it needed to arrive on time.
Okay.
It seems to me that the offer says at the end of the last line of the letter, the next to the last sentence says, please review the enclosed documentation and advise me of your position no later than 20 days from today. Isn't a fair reading of that letter that all it required was an advice of the insurer's position as to the offer?
I don't think so. I'm not quite sure what the author intended with that. Advising on your position is just saying, basically, what are your thoughts about what's happening with this?
Well, that's what that's what the master of the offer said.
Yes, but that is secondary to the sentence before that says you can only be accepted with an affidavit.
Now, presumably you can only accept it with $100,000 also, but that wasn't furnished, and nobody's complained about it.
Correct.
I mean, it seems that a fair reading of this offer simply calls for a response. It doesn't call for a complete packet of all of the required documents.
But you can only accept with the affidavit. The 20 days, I think, deals more with just the limitation for discussing the offer. I don't know exactly why it's in there, but I do know that the offer was withdrawn on August 23rd. So it was gone.
If I'm understanding correctly, then you're saying that if I sent a check for $100 and the affidavit, $100,000 and the affidavit was missing, there would be no acceptance. But if I sent an affidavit and no check for $100,000, we have a deal.
That's right, Your Honor, we do.
Oh.
But then again, if I took the $100,000 check and cashed it, we're done. Because I have by my actions, I have waived all of this stuff. But that didn't happen. Instead of accepting any money, which was never sent, what they did was on August 23rd, they withdrew the offer.
So what if the response instead was, I am, within 20 days, I'm advising you of our position, we accept. Would your arguments be identical?
No, there's no affidavit. There has to be the affidavit.
And to follow up with Judge Swan's questioning, there had to be an affidavit, but there didn't have to be a check.
Correct.
Okay.
Which is the usual course of events. You reach the agreement and everybody quibbles and fibbles, and then the check eventually arrives and you cash it and you provide releases and you satisfy liens and all this other stuff. But The initial thing, once you get past this offer and acceptance, you've got a contract. Well, we didn't get past offer and acceptance, and we never had a contract. As far as receipt, you only get to whether it was received or not, the mailbox rule and its various variations, if there was an affidavit that was actually sent, and there was no affidavit. But assuming the declaration is an affidavit, then you get to whether it was received or not.
And your expert says it wasn't.
Well, he said it wasn't, and then the legal secretary and the paralegal both said it wasn't received. They said actually they didn't actually get a copy of it until the motion for summary judgment when they finally got a copy at the office. So if you go to the second step, you get to issues of fact, and I suppose that would have to be resolved by the fact finder, which is why I like the first issue so much better than the second issue.
What in the offer letter tells us that the affidavit of no insurance needed to be received within 20 days?
I think my mind took a vacation month. Could you ask that question again?
What I'm referring to is that the 20-day, as I read the letter, and maybe I'm missing something on the first page, as I read the last page of the letter, the 20 days from the date of this demand is linked in the same sentence, only with advise me of your position. It's not, the sentence talking about our offer can only be accepted with an affidavit doesn't put a time frame on that.
No, it doesn't. My impression, the problem is, I sort of got an impression when I read that, and I think the impression was the same one that the insurance company had, was that they had 20 days to respond. And on the 20th day they did respond, they simply did not respond properly. They did not give the affidavit, and in fact, according to the people at the office and our computer forensics expert, the declaration itself was never sent. So they didn't comply. Which takes us down to the third and final issue we've already touched on. I don't know how much more discussion we need to do about it. Was ADC. Our position is it doesn't apply to this particular situation at all. And with that, I've really gone through my house of cards, and I'd like to retain my remaining time if I can.
If I might just poke at the House for a moment. Ultimately, this doctrine that you're advocating, this hyper-technical sort of master of the offer doctrine with absolutely no substantial performance, in quotes, component. I understand this is formation and not performance, but there's no substantial compliance component to the doctrine. There's no good faith component to the doctrine. What's the best and most recent Arizona case that takes such an extreme view?
I don't know if it's an extreme view, but the case that I like best is the one with the hardest to pronounce, Clark versus Compañía Ganadera de Canamillera, SA. And it's basically saying that acceptance must comply exactly with the terms of the offer. And this comes up occasionally. The trouble is it's been so ingrained in the minds of lawyers and judges for so many centuries that it's just sort of an automatic thing, and it's fairly rare that this situation arises. I don't know why it caught the trial judge by surprise, and my esteemed and beloved colleague across the aisle insists that the mirror acceptance rule doesn't apply. I don't know why it doesn't.
When you said it doesn't happen very often, in cases when it does happen, when a plaintiff's lawyer receives a fax or other communication from a carrier saying, yes, I accept your offer, here's a declaration, here's other materials, and the plaintiff's lawyer opens it up and doesn't see one of the items that the plaintiff's lawyer thought was required, doesn't the plaintiff's lawyer have an obligation to get the carrier's lawyer on the phone and say, hey, where's the third element that I asked for?
No, I don't think so. I know most plaintiff's lawyers would, and for whatever reason, this plaintiff's lawyer did not. And I don't think there's any duty to do that. If you don't get your mirror acceptance, then there's no deal, and you can just walk away from the table and actually formally withdraw the offer, which they did a couple days later.
And I know it does seem that if one wants to be so persnickety about the terms of an offer, one should draft it more carefully, because mirror acceptance, it would seem to me, could mean I've advised you of my position in 20 days. That's because those are the terms that the trial counsel wrote.
Well,
Why aren't we being as careful about those terms as we are about the mere acceptance rule?
Well, you have to read you have to read the offer as a whole, and the part of the offer that you omit in that analysis is that it specifically says must be accepted with an affidavit. And if there's no affidavit, there's no acceptance.
And
So reading as a whole. I know this is persnickety, I know it's hyper-technical, but it's the glory of the Charles Dickens common law.
do we read the offer in the light most favorable to the offeror or the offeree?
Offeree, I believe. You read most things against people who draft them.
Right.
I hope you don't read my opening brief in that way, however. I'd like to reserve my remaining time.
Thank you.
Thank you.
Mr. Robbins.
Good morning, Your Honors. My name is Christopher Robbins. I'm here on behalf of the defendants, appellees, Pfeifer. I'll start the same way I did in the trial court. We're having the hardest time giving away $100,000. And we don't quite know why. On July 26, 2017, Ms. Campbell's attorney sent the Pfeiffer's insurance company, State Farm, a time limit, policy limit, demand letter in a simple car accident case. This happens all the time, every single day. As the court has noted, words do matter. And no matter what Ms. Campbell's attorney intended, this is what he wrote. Please review the enclosed documentation and advise me of your position no later than 20 days from the date of this demand. State Farm's claim specialist replied within 20 days using that exact language as we've been trying to instruct our claim representatives and claim specialists to do. I am advising you that we accept your $100,000 policy limit demand. There was the offer, we'll sell for $100,000. There was the acceptance, we will pay you $100,000. That is all this settlement agreement involves.
Well,
just
not
the
really.
Well,
By its terms, it involves two other documents.
Well, as the Emmons case pointed out, this is how you settle cases. The injured plaintiff wants money. The defendant wants to be released from further liability. Those are the two primary, those are the performances that are requested. This attorney for Ms. Campbell did not want a notarized piece of paper. He could care less whether he got a notarized piece of paper. He did want confirmation of the policy limits, which is absolutely understandable, and which is something that State Farm could do. They can confirm, yes, their policy limits were $100,000. He also asked, and we see this all the time, and understandably, plaintiff's attorney want to know if by chance my client's injuries are so severe that they exceed the policy limits, are there any other assets to pay a judgment? In this case, he didn't even ask for other assets. He asked for an affidavit of no other applicable insurance.
What evidence is there that that affidavit or declaration was sent to the plaintiff's lawyer?
We submitted, once this became an issue, we submitted from the computer record at State Farm showing that, yes, in fact, that affidavit had been, it's called e-fax, which is something I wasn't familiar with before, but I'm learning about now. It had been e-faxed along with the acceptance letter.
Is there an image of it attached to an e-fax file?
No, Your Honor. And in fact, here's something really, really curious is each of these items, the acceptance letter, the certified copy of the policy, the declaration, it was a declaration. We can see that. There's no way around that. It was a declaration. And the release, the proposed release, all came under separate fax cover sheets. And they received everything and they received everything except, for some reason, the faxed cover sheet that was the cover for the one-page declaration. If you look at the second page, it's just the information we generally find at the top of a fax page. And I cannot explain that. It's the date and time, and it says fax server, and it has some sort of reference number. I don't know why. I don't know why they didn't receive it.
It was really dark, maybe it didn't get faxed.
Well, and that's a possibility too, Your Honor, because I obviously wanted to look through the file to try to State Farm's claims file to try to find it, and the best copy that I could find that was actually executed was dark, and it is hard to read.
So in any event, you would have to concede that notwithstanding what the trial court found, there was a material issue of fact as to whether, whatever you want to call it, got to the plaintiff's lawyer within the 20 days.
Well, I guess the trial judge relied in large part upon common sense and just reason, because our computers show that it was, State Farm's computer shows that it was sent. They actually have a cover sheet that would have been the cover for that particular document. They admit that they received everything else.
Counsel,
and in addition, the claims specialist actually called the attorney's office and asked if they had received everything, and they said yes.
Wow.
They were getting ready to send out the hold harmless agreement because it's all going to be done.
Does the record show that the declaration was sent or that something was sent?
Well,
Because I think there might be a difference. And if I heard you right, because I see, they admit to having received 7 separate faxes, and, they tendered an expert talking about what the expert found. And I hear you to say that the record shows faxes were sent, but I don't know that I read the record as saying yes, and the record shows that this declaration was sent.
well, if you look at Exhibit 3, I believe it is, to our statement of facts, is the computer printout, State Farm's computer printout, and it does actually say affidavit. I'm pretty sure it says affidavit for both August 15th, the date that everything else was sent, and August 25th.
The cover sheet says that.
The computer printout says that. The actual cover sheet, I do not believe says this.
Okay.
This is what.
May I ask why?
Sure.
I love antique technology, I really do. But who faxes anything? Why not just solve this problem by sending it in the mail, if you like the antique way?
Your Honor, this is going to be unbelievable, but I've actually had a couple plaintiffs' cases lately, and the insurance companies want to fax things.
Well, now you
And
know
I
to
don't-
tell them don't.
And
that may not be
I'm talking
ideal.
about other insurance companies that I do not represent.
Uh-huh.
And I don't know, and I will tell you as well that I have just this year learned how to do the fax on the computer. You no longer go to a machine and send it through. You do the fax straight from the computer. And I believe when they say e-fax, I believe that's what they're talking about here. But let's go on to the really big issue.
There was a material issue of fact as to whether the affidavit/declaration arrived. The plaintiff presented sufficient evidence with the expert witness and the testimony of the office people. Isn't that right?
I think I have to concede that, Your Honor,
Okay.
because they've denied receipt. But now here's the practical, real world that we live in. These things happen all the time. The claimant's attorney makes a policy limits demand. The insurance company or the defense attorney evaluates that and says either yes, we accept it, or no, we don't. here, there is absolutely no question whatsoever that the claims specialist accepted the $100,000 policy limit. So if they had any question, at all, just ask.
Well, we
I
may
mean,
get back, we may
I'm
get back to
sorry.
that in a second, but doesn't the fact that that State Farm, by the appointed date, sent an acceptance letter, a declaration page, and wanted to send a declaration / affidavit,
Said that we did.
doesn't that show that State Farm understood it needed to accept the offer by sending a response that precisely mirrored the offer?
No, I understand what you're saying, Your Honor. But the thing is, these things happen over the phone, they happen by email. You say that the insurance company, the plaintiff's attorney makes a demand, and the insurance company decides yes or no. In this case, the insurance company decided yes, we'll pay the policy limit to obtain a release for my clients, the Pfeiffers. That was very important. And so, a couple of things. First of all, even if that was error, it's completely harmless because there is no other applicable insurance. So it's a nothing. And here's the other thing, and this is something that I think a lot of plaintiffs' attorneys don't understand, is that the insurance company has no contractual or legal obligation to ever do a declaration or an affidavit of no insurance or no assets. That is not something the insurance company can do. The insurance company can only say, here's the amount of money we'll pay, and here's confirmation of this insured's policy limits.
So what you're saying is this failure, if a failure occurred, is not going to set up State Farm for a bad faith claim. So
absolutely. The Pfeiffers would not have a claim, so they have nothing to assign to Ms. Campbell. So the bottom line is she will never recover more than the $100,000 policy limit from State Farm because the Pfeiffers swore under oath, under penalty of perjury, we have no other applicable insurance, we have no assets to satisfy an excess judgment. I was not in the course and scope of employment, so there's no other employer's policy to do this. And State Farm will never be obligated to pay anything more than the $100,000 policy limit because that's the limit that its insureds chose.
so that doesn't really.
So we don't know. Wisdom would suggest in this situation where there's only $100,000 available, no matter what you do, win on appeal, win in the trial court, no matter what you do, the most you're ever going to get is $100,000. And so wisdom would suggest that you accept that before, causing both parties to incur all this time and expense and attorney's fees.
Let's put wisdom to one side for a
Sure.
moment and
We
talk
Absolutely.
did
about.
that before when we were talking about the maroon paper.
You're right. Now, I want to get back to that. I wouldn't do as good a job of pronouncing the case name as Mr. Abney did, but how would you distinguish the case about the mirror acceptance rule? I mean, as irrational and Dickensian as it may be, is it still a binding rule?
No, Your Honor. I mean, as you suggested, this isn't a complex commercial contract where the parties are hammering out the terms and figuring out. This is the plaintiff wants to know how much money I can get. The insurance company wants to obtain a release for its insureds. They came to an agreement. They settled it. The case was done. You don't go any further than that.
So if you prevail here, is this a publishable opinion because we're changing the rules of acceptance in Arizona?
No, I think this is really curious. Every single Arizona appellate court that I could find, with maybe one exception, has the strongest possible policy in favor of finding settlement agreements and enforcing settlement agreements. The Robertson versus Alling and the Perry versus Ronan and especially Hayes versus Fisher, which is strikingly similar to this case. They all say we're going to enforce settlement agreements when we can. That's the public policy of this state. This is a different breed than one of those, a real estate transaction where you may have 100 pages of documents, or some big commercial contract where you have to know exactly how many widgets are shipped by this state and what the cost is and all of that. This is a different breed. This is something that happens every day. And, so if they want to tell, the claim representative, well, you can only accept my offer by, standing on one leg and clucking like a chicken. No, the law does not require that. The law has some basis in reason and common sense.
If indeed that's true, and is there any authority for the proposition that the plaintiff's lawyer who receives the acceptance, it's printed on maroon paper rather than red, or vice versa, I forget that hypothetical, needs to call State Farm and say, looks like you intended to accept, but it's not exactly right?
I don't have authority for that, Your Honor, because it seems like such a matter of common sense. If you really, really needed that document, and it said, the claims specialist had every reason in the world to provide it. She wanted to get the claim settled. She wanted to protect the insureds. She wanted to get the file off her desk.
Well,
So it just seems like a matter of common sense saying, oh, by the way, do they have any other insurance? And she says, no, they don't. I don't know why.
But if she really wanted to get the file off her desk and there was all this problem with fax transmission, why not take action before the before the motion for summary judgment was briefed?
Just because she's got
plenty of time. Well, she can't be that busy. There's plenty of time to stick a copy in the mail, to scan it and email it, to drive it over herself.
I agree, Your Honor. That would have resolved everything.
So why not? Do we have anything in the record to tell us why that didn't happen?
No.
Okay.
This is standard operating procedure, and Mr. Abney cited a case from another jurisdiction about accepting faxes, and if it's basically the substantial equivalent. So all of those things here, it's a different type of situation. There was certainly substantial compliance. There was a good faith effort. Everybody intended to resolve this claim, and that's what happened. And just one note on Rule 80C, besides what's already been said, is that now this is in civil litigation, subject to the rules of civil procedure, but it's interesting that the rule itself talks about the exceptions to when you can have a declaration. And it says, the rule does not apply to a deposition, okay, well that's in litigation, to an oath of office, well that's not going to be in litigation, or an oath required to be taken before a specified official other than a notary public, well that's not litigation. And Rule 80A, all three of the cases that I cited earlier, both said, well, Rule 80A applies to pre-litigation settlement agreements. Why wouldn't Rule 80C apply as well?
Well, I think Mr. Abney would say that the common law would trump a court rule. If the common law requires a mere acceptance, then the rules they offer require something different.
We're going to accepting Mr. Abney's rule will completely disrupt settlements of personal injury cases. It'll completely change the law in the state. And I don't think that's where we want to go, especially when the case law, even from the Supreme Court, says we favor enforcing settlement agreements. We're going to find any way to enforce them. And as I believe Judge Swan, you pointed out, is that the demand letter itself, he was the master of that demand letter, and they, if nothing else, certainly fully complied with what was actually stated in the demand letter.
Counsel, let me push back just a little bit on your ADC point. Wouldn't it be sort of odd if a rule of procedure applicable only when litigation is filed would be used to change the substantive law of common law contract for when an offer is accepted? That doesn't happen very often, to my knowledge, if at all.
Obviously, neither one of us could find any law on the issue, and I hope the court can have more success than we did. But again, from personal experience, I know that we use declarations in other situations as well, just because sometimes there's not a notary available. Sometimes people can't find that notary public, and the very, very bottom line is, it doesn't matter. It's completely harmless error in this case because there is no other applicable insurance. And I've run out of time, and I appreciate Your Honor's attention.
Thank you. Thank you very much.
Please, the court, just a couple of brief points. Hopefully I can say them without getting my foot in my mouth. I appreciate my colleague bringing up the policy in favor of enforcing binding settlement agreements, and the point is you have to have the binding settlement agreement before the public policy goes into effect. The other part is, I think Justice Oliver Wendell Holmes said something to the effect of the life of the law is not logic but experience. I hope I got that right. And the experience of the common law has been that you demand certainty and mere acceptance. And I know we talked about hyper-technical and Dickensian, but I believe there's a reason for that, so there won't be quibbles later on about whether you've accepted or not.
I'm glad to see. What is the reason for the rule that would distinguish between red and maroon paper?
I don't know. And
I don't either. I have to confess, while I'm aware of some of the long line of cases on the minor acceptance rule, applying it in this manner seems to cast aside all commercial reasonableness and engage in the playing of a game just for the sake of playing the game. Why would we embrace such a rule? Well, how does that help people organize their affairs for reasonable commercial behavior?
Well, it helps you organize your affairs because if you have any sort of knowledge of contract law, you know that if someone says you can only accept in a certain way, you have to accept in that certain way or you're not going to have a deal. So that kind of certainly facilitates commercial transactions because everybody knows what the rule is.
I appreciate that you're trying to get this back to the argument about the facts, and I'm not going to respond by delving into the drafting of the offer again, but from a more abstract perspective, how does a rule that allows a party to thwart reasonable expectations in contract formation by insisting on arbitrary technicalities serve anyone?
But the phrase you used was reasonable contract expectations. If I, as the offeror, have an expectation that the only way you can accept is by doing exactly what I ask you to do in the offer, that's my reasonable expectation. Now, you, as the offeror...
So I've served my position in 20 days. Done.
Well, no, that doesn't... because you still have to... It says the only way you can accept is by providing two documents, and one of them is an affidavit. This offer can only be accepted, and those are the key words. And I know the common law chafes at times, but this is the common law rule that's been declared by our state Supreme Court and by the United States Supreme Court, as well as by this court in the past. And the common law being the rule of decision in Arizona, we have to follow it until, in this particular instance, the Arizona Supreme Court changes it. And the Arizona Supreme Court has shown no sign of walking away from the mere acceptance rule. And I hope it doesn't, because it really does provide some certainty. And I know it seems Dickensian when we're at the extreme limit of things, and we are at the extreme limit here. But when you say you can only be accepted in a certain way and you don't accept it that way, there's no acceptance.
There was a suggestion that it was impossible to set up a bad faith case on these facts, and I'm inclined to agree. Is that, am I wrong? Is it possible to set up a bad faith case?
Other than my colleague bringing that up in his briefing once, I don't understand what he's talking about. We're not worried about that at this point, and it's never really, other than him bringing it up. But he has a very creative mind, and he brought up this interesting idea. I don't know where it came from. It's not in my mind.
Is it relevant? Is his argument about, or where he characterizes this as a harmless error, which I think means to say it doesn't help your client at all to have, if you are able to reject the settlement, it doesn't help your client at all. Does it matter?
Well, it may or may not. It depends on if the Pfeiffers really actually do have something outside the insurance policy, and we won't find out until we get back into court and deal with the case on the merits.
But does it matter to our resolution of this contract?
No, Your Honor, it does not. And I, not having my glasses on, I can't tell if I have any time,
You
but
have 2 minutes left.
well, I will cede my time to the court, and with great thanks for your attention.
Thank you very much.
Thank you.
Thanks to both of you for your argument and your briefing. We'll take the matter under advisement and issue a decision in due course, and now we will adjourn. Thank you.